opportunity to introduce our esteemed guests who have accepted our kind invitation to be a part of this panel today. Thank you, Nishant. Thank you, Jonathan. Nishant is a graduate in law from GNLU, Gujarat National Law University, and a Glass Scholar. He's a dynamic mediator and co-founder of the Pact. He was awarded by Mr. Kiren Rijiju, the ex-law minister of Government of India, for his contribution to the field of conflict resolution. Nishant is an accredited mediator at various prestigious institutes like IICA, Indian Institute of Corporate Affairs, IIAM, Indian Institute of Arbitration and Mediation, to name a few. He is a distinguished author and has contributed to the book Mediation and Conciliation in India, which was published by Wolters Kluwer. On the other hand, we also have with us Jonathan Rodriguez, who is a certified mediator with an academic background in psychology and law from Goa University, India. He has also completed his LLM, his master's in mediation and conflict resolution from the UK, and he graduated with a distinction from there. With Nishant, Jonathan co-founded the Pact, which is a firm that is dedicated to mediation awareness and training. Nishant and Jonathan, along with their other team members, they have penned a very interesting and a very interactive book, Mediation Simplified, which has helped every student of mediation in understanding the nuances of mediation. Whether you're a student or you're a professional, this book will help you gain additional perspective on how mediation can be offered in its variety to ensure that disputes are resolved in record time. Whenever there is any dispute, whenever siblings fight, partners fight, families fight, one of them automatically turns into a mediator to help with resolution. So while mediation has been practiced and implemented since time immemorial in India, it has also become a very important tool for resolution of disputes, be it in commercial matters or be it in family disputes. To aid parties in effectively using this tool, our guests have tried to simplify the concept of mediation for parties. Mediation Simplified, the book that has been penned by our guest members, along with their other team members, is a genuine attempt to illustrate the theory of mediation in a very practical and a relatable manner to ensure that people or every student is able to understand and is able to implement those soft skills that this book tries to impart. The intricately curated chapters also allow the readers an immersive experience to reflect on conflicting simulations and apply these practical tools to strategically de-escalate, objectively analyze, and amicably resolve the conflicting situations. Mediation Simplified is India's first interactive workbook on negotiation and mediation, and it aims to support the academia who are tasked to either research or teach the subject at the universities across the country. Now, without much further ado, let me ask Nishant, how did they come up with this idea of the book Mediation Simplified?
Thank you so much, Kritika. Thank you for the wonderful introduction, and to CIRC and WeVaad for having the two of us here. And thank you to all the participants for joining in. I'm sure the fact that we will all have something to take back home in terms of our learnings. We will be learning from you and vice versa. So look forward to having an interactive session here. And Kritika, thank you for the first question, where we are talking about how did the idea of the book come up. So it's a very interesting story. So we at the Pact, we started our operations about in 2015, right? And we realized one thing, that there is a need for mediation in India, but there is not too much awareness and there's limited training. Now, if you go to, if as youngsters, we ended up going to lawyers, senior lawyers, तो वो कहते थे, बच्चे क्या पढ़ाएंगे, ठीक है? Which is true, which is a backlash, we would face. So we said, you know what? If we cannot change the mindset of A category of people, let's go to B category. So students are someone who just, entered law school. They would be, open to knowing. And that is what we focused on. We started with 2-day workshops at various law schools, and the idea was always to create a ecosystem. By ecosystem, look at it as a complete circle where we first said, okay, awareness ka zarurat hai law schools mein, right? Because not all universities taught that subject. So we started with 2-day certificate programs. Over the last 7 years, we trained close to 12,000 plus participants across 57 different universities. So after having done those workshops, there would always, every single workshop would have this excited bunch of students who would then want to say, okay, we want to do something in our university. Okay, so circle ka we go to stage number 2, where we would then assist them in creating the ADR cell. Okay, so that every year a student is able to have one touch point with mediation. Ecosystem ऐसा बनना चाहिए कि वो mediation student ऐसा याद रखे that even when he goes to his practical sphere or where he practices, at least once in his lifetime of practice, he should recommend mediation to his client. That was a small vision. So from the workshops, we help create ADR cells. From ADR cells, we help create annual intra rounds so that students can participate in mediation, role plays, compete in the university. Then we assisted them in setting up national competitions. So when we started off, there were only 2 or 3 national competitions. To now there are almost 35, 36 in this country. Every law school wants to have a mediation competition of their own. And I think now we've reached a stage where there is where students are aware, right? There's an ADR cell, there is an annual competition inter-round that's happening, and there are other competitions that are taking place, correct? So the vision, the aim with which we started, the boot camps, kind of has fructified, and therefore we have now launched Mediation Simplified. And this came with the thought that the Bar Council of India has now made mediation a mandatory subject, right? But because mediation is a skill and not necessarily a theoretical subject, like arbitration, IPR have a lot of theory involved in it, but mediation has a lot of skill involved in it also. So we said, okay, what can we create so that teachers can give these students a practical understanding, right? And because teachers are using the book, these students can also use that book to be able to practically understand mediation. And this also goes for non-lawyers, right? Non-lawyers or even lawyers who are not so well aware of mediation, to have a simple book, not a commentary, but an interactive workbook where you learn a topic or you read a topic and you do exercises. You read a topic, you do exercises. So what we used to do over those 2 days across the country can now be done through this book. That is where the idea came in, and it completes the first circle of PACT's training and education life cycle. So that is where the idea came from.
Thank you, Nishant. Your book sounds very interesting. My question is to you, Jonathan. You called negotiation as antecedent of mediation. So what soft skills would mediators are indispensable to be it an effective tool for dispute resolutions, and how would you advise students to develop the same?
Thanks for the question, Renali. Once again, thanks, Kritika and Navneet, for having us on this session. First of all, I think it's a bit misleading to call them soft skills. I know it's something that we use in our common parlance, and I continue to use it because for those of us who try to practice those skills, we know how hard they are. So it's a bit deceiving to call them soft skills. But I believe the reason why they're called soft skills is because they invite us to touch upon the more delicate and sensitive parts of us as human beings, and that those are emotions and feelings that we sometimes don't like to address. It is a very crucial part of being a mediator and a conflict resolution professional. I mean, there are various soft skills, but let's just take out the equation of being a mediator for a second, and just think about just us as just individuals in our professional lives. Things like reframing, summarizing, asking open-ended questions to people, listening without judging the other person who's speaking. These are things that are actually expected out of us as human beings, but we're so busy in our worlds that we are not being able to practice this. We know it's the right thing to do. We know it's the right thing to practice when we are engaging with somebody else. When somebody else comes to us with their problems and they're telling us about their problems, how many of us actually listen without judging them or diagnosing their problem? Most of us listen to respond. Most of us listen to give some feedback or to give some advice or to give a solution or to give them our gyan about what we think is the best thing going forward. So very few of us actually listen to empathize and understand. And that's where a trained mediator makes a difference, right? And now you'll be like, Johnson, are you always listening to people like outside your role as a mediator? Absolutely not. At the end of the day, we are human beings. In a real life scenario, I'm sometimes selectively listening. Sometimes there's so much happening around me that I can't be listening to you attentively. But when I put on the mediator's hat and I'm sitting in a room with two parties who are in a dispute, who have engaged me and hired me to be that mediator, to help them talk and fix things for themselves, that's when I actually have to listen. So that's when I put on the mediator's hat. I try and listen even outside the mediation table in the mediation group, but at least for that 1 hour, 1.5 hours that I'm hired for, that's a skill I bring to the table, to listen, to empathize, to summarize what's happening. If two parties cannot be framing sentences in a constructive, civil manner for a dialogue, I help them construct those sentences better, help them. They know what they want. Remember, as mediators, we are not there to tell them what they want. So they know very well what they want. Our role as a mediator is to help them converse properly. And those are the soft skills. So firstly, you have to train yourself to be able to exercise those soft skills yourself. And because then you will need to start coaching parties in the room itself to say, hey, because as a mediator, what my practice is, before I bring parties to a joint session, I always ask the parties, what do you think might be your first few lines you would be saying to that person? It's almost like a bit of a rehearsal. And because I need to know what they're going to say. You can't come into the room and just, go full guns blazing and bash out at the other side. That mediation is ruined. So I work with them and I coach them, and they'll say, this is what I want to say. And I'll be like, do you think you might want to frame that bit slightly differently? Because how do you think they might respond to that? And so there's a bit of that goes on. So it's a bit of soft skills coaching, as you want to call it, that takes place for a mediator. And so first of all, you have to learn the skill yourself and practice it. And there are different places where you can learn the skills. There are a lot of organizations that do trainings in soft skills, in negotiation and mediation. PACT has done that for the last 7-8 years, but there are many others who do that in India as well. And many others who will continue to do that. But it's about also trying to practice that as much as possible in your daily life outside the professional space, because if you do it outside the professional space, it'll start to come naturally to you in the professional space as a mediator. But yeah, that's my very babbling answer to your question. Sorry about that.
Thank you, sir.
Very interesting. I actually, when you were explaining this, I recall that these days we listen to reply, or rather we hear to reply. We don't listen to understand, which is one of the crucial points that people, even in a regular discussion, they tend to avoid, which is what can greatly help even in a regular conversation. So thank you for that. Before we continue with the questions, just one question that has been put up, which is how can a participant win a book award? I request all the participants to be attentive as well as note down their questions. We have a few questions for the panel members. We assure you that once we are through with those interesting questions about the book, we'll give you an opportunity to ask these panel members all the questions that you have about the book, about mediation, or about anything in general after we are through with understanding the nuances of this book for some time. Nishant, I have a question for you. I want to understand, in Mediation Simplified, while we consider mediation to be such a simple process wherein everybody wants to don the hat of a mediator, enlighten us about the simplification of mediation in this book. What has been simplified?
Okay. So that's a very pertinent question. And let me, I would want a volunteer here to help me answer this question. So is there anyone, is there any viewer, attendee, participant who would like me to help? If I can have their hands raised and come on camera for 2 minutes. I just need your assistance to answer this question.
It's a great chance to win the book, if you ask me.
Sure, I think the book is for the
You've offered us a
participants.
cheat code.
Anyone here? Maybe Devashri, Ram, Rahul, anyone? If not, then I'll just ask Navneet to help me in this. Anyone out here? Okay.
Students, this is a wonderful opportunity.
Digant, why don't you help? Digant, why don't you volunteer? Digant, are you there?
So
Why don't you volunteer? Digant or Preeti?
Yes, sir. Yes, sir.
Yeah, please.
Okay. So Digant, can I have a video on for 2 minutes?
Actually, my laptop does not support the video as of now.
Okay, chalo. So let me ask you this then. Okay. I'll take 5-7 minutes in this small interaction I'm going to have with you. Now, tell me something. If I come to you as a lawyer, sorry, if I come to you as a client and you're the lawyer, right?
Yes.
And I say that I want to file for a divorce, right?
Okay.
So the first thing that you will say is, TK, you have to send a notice to the other party, right? And you have drafted a notice and you sent it to the other party, and now we are in court, right? So what is the first step that happens in court, according to you?
They hear your pleas, I believe.
Correct. So maybe first you put in your plaints. Before they hear it, you draft your plaints and you put it in, correct?
Yes.
Then once I have put in my my plaint, and there's a written statement which is a response.
Yes.
Correct. After the written statement, then of course there is simplifying it further. There is the you'll go into the facts and arguments, drafting of issues and then arguments, correct? And then there might be certain interim orders passed, and towards the end of it, we will have the final order that is given, right? So, Digant, according to you, just this process in a district court, how much time do you think it would take? A rough guess.
I believe half a year, 6 months.
Half a year. Are you a lawyer?
No.
That's why you're so optimistic about it being 6 months. But Navneet sir, what do you think? How much time? So according to Digant, it will take 6 months. According to you, how much time do you think it'll take? What's your guess?
My sense is, if the parties are professional enough, they may close it somewhere between 3 to 4 years, but it can very well take 5 to 8 years as well. And there are matters which land up in Supreme Court, and it can very well take 15 to 20 years. But I would hazard a guess 6 to 7 years would be the average.
Correct. And then you know what? There is a client that kind of came to us. So they were going in for divorce, right? And they were about 9 months in the court. And someone told them to go in for mediation. They came in for mediation, and they were stuck on the point of alimony. And at alimony, the husband said that, okay, there is a list of 5 things that I gave to you which you need to return to me. And the wife said that, no, but I don't have these 5 things. Rather, you need to give me 7 things and X amount of cash, right? And after having communicated and after having expressed themselves and vented out whatever they were feeling, both the parties said that, okay, let us in the next session, they believed a lot in the Gita. They said, okay, why not? We will swear by the Gita and say that, okay, these are the things that I have, which you had given to me. You do the same, and I will take it as it is, right? And in the next session, they actually came, they swore by the Gita. The husband said, these are the list of things that I have to return to you. The wife said, okay, these are the list of items that I need to return to you. They agreed on an alimony and exchanged, right? Now, what kind of a difference, and this is something that I can ask Digan. Digan, what kind of a difference did you see in the court that you discussed, where we said that, okay, the case can take from 6 months up to 4-5 years, versus what happened in 2 sessions over here? What is the difference that you saw? And maybe even the viewers who are listening to us, please write in the chat box as to what is the difference that you saw between the two processes.
I personally believe the things that were prerequisite were cut off in the session process.
Such as?
All the filings and all. Those
Okay.
are
So
not
documentation was one of
Yeah.
them, correct? Kritika, how did you think that was different?
Hi, can you hear me?
Yes,
I believe that the approach was very different in
right?
scenarios, which is where I believe that if your approach is to ensure that, we want to settle the dispute amicably,
Right.
not fight it out in court.
Fair enough. So just like, and I completely agree, there was, saving of time, cost, energy, etc. But similarly, just like what the interactions I had with Digan is what the book is also doing. It is taking on concepts and simplifying them in a single paragraph and maybe a page or 2 pages, right? And after that, it is giving you an exercise to do with it. So you read the text, you read the theory, and then you're applying it. So when you apply it, it kind of sticks to you. And I'm sure Digant will never forget this example that I've given in, even future. So that is what the book is doing. It is simplifying the entire concept. Even if you're a non-lawyer and you do not understand mediation, you can read the theory and then you apply what you have read. That is how we are simplifying mediation, so that you can get an understanding of the practice as well. That is what mediation simplified is doing, and which is where the simplified comes into play.
Thank you, sir. The explanation was quite simple of your book. Jonathan, sir, I want to ask what structural and procedural impediments you feel as a mediator when you resolve the mediation dispute online and offline?
Yeah, thank you for the question, Minali. So I think I'll start off by just adding on to what Nishant just said, actually, just so that everyone on this call doesn't misunderstand. He's given a fantastic example there, but just to remember that at the end of the day, you will need to take your mediation agreement to court to finalize the divorce. Okay, so you can't come to me and I can't grant you a divorce as a mediator. What I help you do is I help you have a consensual divorce instead of having a contested divorce in court where everything is watched in public and everyone is there to watch it. Media, neighbors, depends how famous you are. If you are, one of the Khans and you're divorcing one of your wives, then yes, you're a famous actor, and so all the media will be there to find out all the dirty secrets. Or if you're just nobody famous, then it'll just be your neighbors coming there to see what's happening in your life. So we avoid that. We say, come to the table, do the dealings in private, do your conversations in confidence, come up with the terms of your divorce, and then take that agreement to court. So your lawyer will then help you take that to court. And there is a procedure, but it's a shorter procedure. It's a more effective procedure. Otherwise, I just want to make sure that is clarified with everyone on this call, because not everyone might be a lawyer. To your question about I have practiced both as a mediator in an online setting and in an in-person setting. I'm not sure which side I support more, because I've done both sides of the mediation, but I think I've done more in-person mediations than online. And most of the mediations that I have done are designed in a way that everyone who was a major stakeholder and who was involved in the dispute, because one of the most important things in mediation is that everyone who's connected with a dispute must be taken into consideration. You cannot have a blind spot to say, oh, we forgot to ask that person who had a major stakeholder in this dispute whether they also agree to this. Because you might come up with an agreement and that stakeholder can just rip it apart. So a good mediator makes sure that everyone who's involved in the dispute, everyone who that dispute might affect, has been taken into consideration and their voice has been heard. And that's the watertightness of that mediation agreement. If you want to have a good mediation agreement, you have to make sure every possible angle is covered. And so mediators take a lot of effort in this. They use a lot of time before the mediation starts to prep and find out all the different kind of, I would say, stakeholders who are involved. So in an in-person setting, sometimes what would be difficult is to reach out to people who say are disconnected, who are disabled, who probably can't travel, who are in another country altogether. It's too expensive to travel up and down. People who are busy at work, who do not have the time in their schedule to come for mediation sessions. So all that is kind of taken away and made easy in an online setting for sure. But what I miss in an online setting is the personal touch, right? When you're in the room with somebody, you're around a round table, you can actually watch body language, you can empathize better. So it's a bit, I would say, it has both have pros and cons. And at this point of time in my career, I would not know which one to side with. But I think every good mediator and every good mediation institute will now look to see which case is better handled online and which case is better handled offline. So I think that's where the question and answer is. It's about figuring out what's the best mode of mediating for that particular case. If the mode, and sometimes parties come very clearly and say, I don't want to do this online because they fear the online setting. Sometimes they don't know whether it's a trust factor. Maybe they just want to be in the same place. So on the other hand, there are some parties who come and say, I don't want to see that person's face in your office. So I would prefer doing this on Zoom. So it's right now with ODR, with online mediation, we have a great opportunity to say, if you don't want to be in person, you have online. If you don't want to do it online, we have the office scenario. So I think that's where it really, I would say, boils down to, and parties have that final choice to decide how they want to go about with things. There are also situations where
Right, sir. So what should be the legality of mediation in Indian legal system and what it is now?
I'm not quite sure I understand what you mean by legality, but if you're talking about
legality is enforcement of mediation agreement
right.
in the Indian courts.
So very, this conversation can go on for good 2 hours, but very quickly, right now, mediation does not have a mediation settlement agreement does not have the same status of an arbitration award or a conciliator settlement agreement, which are both arbitrators award and conciliator settlement award are taken care of by Section 74 of the Arbitration and Conciliation Act. So that is something that mediation does not have at this point of time today, afternoon or evening in India. But there is a bill in Parliament that we've been speaking about for a couple of years now. It's just not getting through those doors. But if that comes into picture, then mediation will have the same status as that of an arbitration award or of a conciliator settlement agreement, which means that if any of the parties decide to dishonor a mediated settlement award, the other party will have to just basically take it back to court only to enforce it, not to battle it out anymore. It will be just to enforce the agreement. As of today, what a lot of mediators do and a lot of mediation institutes do is they start the mediation as a conciliation and they end it as a conciliation. So that way, procedurally it is a conciliation, but process-wise, it's very much designed as a mediation.
Right, sir. Thank you, sir.
Right. Now, this is very helpful, Jonathan, what you just explained in terms of deciding which disputes, it should be analyzed as to which disputes are more suited for online arbitration and what are not suited for online and are much more suited in an offline setting. Here, I also want to understand, Nishant, do you think COVID has helped in adoption of mediation as a preferred mode of dispute resolution for parties?
Because I think, as I was mentioning earlier as well, prior to COVID, we had this thought process कि courts online तो हो ही नहीं सकता. Forget mediation. Courts online कैसे हो सकता है, right? You would think that, oh, it's not possible. There's so much documentation. There's so much technology. How can you argue? And when COVID came, people were left with no choice, right?
Right.
So when our backs were against the wall, everyone, all courts at that point in time ended up going online, right?
Right.
Which is what has happened with mediation as well. It's just that, when there's a system in place, we don't want to shake it up until there's an external, force that comes, and COVID was that external force which came and which gave it a push where people went online. Even, you know that even our grandparents hated using the laptop, and now they are having, they were having birthday parties on Zoom. So just like that, even COVID has definitely given online dispute resolution a push, where people said that, okay, we can have a situation like this, how to deal with it. And people did come up with, various technologies, whether it's AI, whether it's online course, whether it's online mediation. People did, continue. So yes, COVID did play a major role in pushing that, absolutely.
Nishant sir, has technology affected mediation in India? Has it become more prevalent in India nowadays?
You know what? Yes, it has become more prevalent because, number one, the awareness is there. Okay. The awareness about mediation is there, and then of course the push towards technology has led to the merger of the two. A lot of e-commerce companies are now settling disputes with their clients, through mediation, because they realize that it is not possible to, be going to court for 2,000, 3,000, 5,000, 10,000 rupees matters, right? Because there are those cases. And my point is, when we talk about access to justice, everyone who feels that, okay, they've been wrong, they should have access to justice, just because they feel that the monetary value of the case is 10,000 or 15,000, it will be more expensive to go to court, therefore not get the access or take the legal course. I think mediation has given that platform where even the smaller matters can be mediated. The online space where the coming in of the technology has given that space where even the smaller matters can be mediated, or can be resolved rather, through mediation, without there being heavy infrastructure requirement, heavy economics that are involved in it. So that is what I would say.
So which sectors have evolved in mediation in last 1 or 2 years? That you could say yes.
Go ahead.
Which sectors, sir? Like e-commerce, or the public sectors like RBIs and SEBI, which have more evolved in conducting mediation online?
So in my personal experience, and of course Jonathan can expand this as well, e-commerce definitely has expanded. And then you have, of course, your traditional mediation has also expanded, because now we have so many disputing parties in India, hiring mediators from across the globe, or maybe from different states. So the traditional mediation sector. The other is also the banking sector. So a lot of your credit card loans defaults have gone on to be resolved through mediation and conciliation. So these two areas, in my experience, have really been have really expanded. Of course, your family mediation, etc., were there. But if you talk about two areas where it has boomed with technology, would be the e-commerce and what did I mention the second one? The banking sector, yes.
Banking sector.
Can I just add to that, Nishant? Because I think it's very essential to understand this, that most of ODR that takes place in India is not traditionally mediation. All right, so it is very conciliatory as a process, because, and I don't want to be a hardliner here to say that mediation has to be followed in a traditional way. In fact, I'm someone who professes the idea of having a very eclectic approach, to have different styles to be a mediator. At the end of the day, people want you to help them to talk and resolve. Okay, and that's the bottom line of it. Now, there is a mediation process that is internationally recognized and also recognized similarly in India. And of course, you have it being recognized also by different legislations and the process. The Delhi High Court has got its own rules and norms for it. You have the Supreme Court that has its own rules and norms for it. There are, a mediation institution providers, private mediation institute providers like CMC in Bombay, CAMP in Bangalore. You have Madhyam in Delhi. You have FCDR in Chennai. I might be missing out on a few. IAMC in Hyderabad now, who do also arbitration mediation. But the point is that there is a different process there that what takes place online. So online, it's more, I would say it's more as a conciliation, because online ODR doesn't have time to get into, say, emotions and stuff like that. So it's more like, this is the situation here. I've heard you both out, and maybe you can give a bit more understanding of your perspectives, and then the dispute resolution professional, I don't want to say mediator or conciliator here, but the dispute resolution professional on that platform will say, I think it's best that you all settle for something like this for both of your good, but now what are all taken into consideration. And then it's up to the parties to say either yes or no. So what Nishant's referring to is actually mostly online conciliation, which has boomed massively. But in the traditional space, I think there is a lot of room opening up where a lot of judges are referring court cases to mediation, say in the insolvency sector, family dispute sector, going to crores of rupees. So there's hospitality sector as well. So there's a lot of work that's going on the traditional mediation side, but from an ODR, and I would be very safe to call it online conciliation processes, which are similar to like a Lok Adalat. You have e-commerce and banking, as Nishant says, that are really booming. I just read a recent report that talks about the government wanting to launch an online dispute resolution platform for consumer complaint registration. So that's interesting. That's just news that came out last week, actually. So yeah, there's a lot happening there.
This is very interesting because, except calling the customer care, this actually gives us an avenue to get our disputes addressed in the formal manner, and not just trying to break our head with the consumer, with the customer care helpline, and then, trying to use the social media to build that pressure on that particular company to resolve the dispute. Here, what do you think, Jonathan? What are the challenges that these companies or customers would face in online dispute resolution?
From a process perspective, so once again, I think it's very important we clearly kind of distinguish or rather identify that there are different methods of ODR, and mediation is one of the methods. You have conciliation, you have mediation. There's a lot of online arbitration also that's taking place. So is online arbitration ODR? I'm not sure where these brackets start and end, but I don't see a major con to ODR. I think it's brilliant in its different forms, whether it's mediation or conciliation or arbitration. And there are so many people doing fantastic work. You have folks at CORD who are doing a lot of online arbitration. Agami has been a guiding light to a lot of ODR startups in India, and they've been doing some fantastic work. You have the online policy on ODR that they came up with at Niti Aayog. So there is a lot of work that's going on there. I don't see any major cons in ODR, except for the fact that we shouldn't get too reliant on it. And we should always keep that room open for people who want to come back to an in-person setting, and not get aggressive about the fact that, oh, for the sake of convenience, let's all do this online. I think we should keep an open mind to saying, if someone wants to sort this out in person, then we give them that room to do that, because not everyone might want to just get onto a call and sort things out. And also to make sure that, and a lot of people are talking about this, that the ODR boom is about to happen in India and all that kind of stuff. But I think we have to be very careful of the fact that this process is not abused to coerce and force people into settling disputes. And that's where mediation comes into the picture, and to say that it has to still, if it's online mediation, if the ODR process you've chosen is online mediation, it has still to be voluntary. It still needs to be confidential. It still needs to be neutral. And it still needs to be, at the end of the day, a process where the parties decide what they want to settle. And that's online mediation. If these 4 principles are not there, it's not online mediation. It might be something else. I don't know what it would be. It could be online arbitration, it could be online conciliation, but those 4 principles need to stick there so that it remains an online mediation process. So parties need to be educated the right way, just how you have. So I did a TEDx talk and I spoke about the multi-door dispute resolution system. And I said, instead of just looking at, when you have a dispute, it's just one door to enter, which is the litigation door. You have mediation, conciliation, arbitration, whatever. There are different other doors. Go open those doors and see if it's for you. Similarly, in ODR, I think parties need to be told that, hey, there are different platforms for even ODR. You can do online mediation, you can do online conciliation, you can do online lok adalats, you can do online arbitration. So even it's basically just taking up processes online, that's all, and making it more effective with different platforms and I would say different kind of comfort levels for parties. And each player in the sector has got a different comfort level. They've designed some amazing platforms to make it easier for people to come and access. There is a big question mark about internet connectivity in India, but I'll leave that for another day of argument.
Very well, very interesting. We have got a lot of questions from the audience, and I'm sure once we open the floor for questions, we'll have a lot more. Before we do that, I have one question to both of you, Nishant and Jonathan. While Jonathan, you mentioned about different facets and different features of mediation. My primary question to both of you is that, is there any need to regulate mediation in India, since it's a completely voluntary process?
Well, that's a tough one for me because as you know from my history, I worked with CAM for nearly 2 years. I was very much part of the whole drive to push for the mediation legislation. In hindsight today, sometimes I feel like we might not really require it. We could have just made some amendments to the Arbitration and Conciliation Act instead of codifying an entire process. But then there's another argument that are like 2 little devils in my head pulling me on both sides. Where one says, if you don't have the legislation, no one's going to take mediation seriously. But then there's other one saying, if you codify it, people are going to take mediation too seriously, and suddenly the procedure is going to come in the way of the process. And what do I mean by that? Documentation, how you bring the mediators in. So parties will not be able to design it. Mediators will be, kind of have to follow rules to design their process. And mediation is such a beautiful, flexible process that sometimes codification might not work. I've been speaking to a lot of international mediators who say India might have not taken the right decision by codifying mediation. But then there are also successful stories of codifying mediation. Australia has a codified mediation law. So does Canada. Certain jurisdictions, the US, Ireland recently came up with a mediation law. I know that Mr. Jawad, who's a very loved mediator in India, is going to be speaking with an Irish mediator in a couple of days on another platform, talking about jurisdictions and mediation legislations. So I'm a bit conflicted at this point of time in my career as to where I stand on this, but I do hope that if it does get codified, everyone's voices are taken into consideration and it's not monopolized by certain people who feel it's right. And it's actually debated with an open mind, and every stakeholder is taken into consideration. And there is a generation of young lawyers and young ODR practitioners and young ODR entrepreneurs who need to be consulted before this law comes into force. Because at the end of the day, it's these folks who are going to drive that practice forward over the next 10, 20 years. That's all I can say.
That's a very interesting take on this question. Nishant, what are your views?
No, I completely agree with Jonathan and on that. I was also always in 2 minds, but I think now that the bill is coming, it is important because in my viewpoint from three aspects. One is that it is definitely going to create awareness, especially awareness amongst the users, your corporates, your regular disputing parties. What awareness hoga? Even when the Ayodhya dispute was mediated, there was so much awareness about mediation at that point. Just that one case got that much awareness. So I think with the mediation bill coming and the publicity that comes with it, there will be the awareness. And the second and third are the standards and quality. So there is, it is with the coming of the bill, there will be certain, standards and quality with which, we would want to be in place. So I think those three are important aspects as to why we feel that, the bill will help the practice of mediation.
Right. Thank you so much for your thoughts. Thank you so much for explaining mediation simplified. Thank you so much for simplifying mediation for us today. So now I open the floor to the audience. I request people to kindly raise your hand and we'll call out your names and then you can ask your questions to the panel members. We also have a few questions that Navneet sir has put in the chat box. We also request you to kindly address those. Rahul, you can ask your question.
Hi everyone. Good evening. I am Dr. Rahul Shrivastava. I am a professor at Christ University and I specialize in public international law. So my question is to
So I think your voice is breaking. Would you like to just type the question in the chat box?
Anyone can answer. One pertinent here. Voice breaking, is it not coming to you?
Now it's coming. Now it's better, sir.
Yeah. So I just want to ask you one question which Navneet sir has already put beforehand. That is, who can become a mediator? So this question is very important as you are speaking on a topic of ease of justice. Now, we all know that under the Contracts Act, there is a strict provision which says that an agreement which ousts the jurisdiction of a competent court cannot stay except for the exception in case of arbitration. And in Arbitration Act also, we see that there are disputes of commercial nature which have been limited. So what kind of disputes are you envisaging? Are you envisaging all kinds of disputes can come under the umbrella of mediation? Or where can we draw the line? And the second thing is that how do you ensure justice? Because justice can not only be left to the parties, but there are several interests, especially public and sometimes, societal interest. Like Navneet sir asked a question about economic matters, then the interests are different, which needs to be balanced in order to achieve justice. So easing out justice or, totally ignoring justice, there is a slight balance which you need to maintain through mediation. And I would like you to touch upon these areas and tell as to how a non-lawyer, are we envisaging any expertized mediation where a non-lawyer would have expertise? For example, let's say construction industry. Construction industry have many engineers participating in dispute resolution process. Similarly, environmental matters, we have non-lawyers participating. So I just want your take on these areas. Yeah, thank you.
Yeah, I think Nishant, I'll probably just say a few words and you can come in. First of all, thank you, Mr. Srivastava, for those questions and comments. I think I agree with everything you're saying there. I have responded to Navneet's comment in the chat box about who can be a mediator. I was just referring to the fact that the last two batches of India's only postgraduate course in mediation that's run at the Maharashtra National Law University in Mumbai. 60% of those people, participants there, are not lawyers. They're either police people, psychologists, teachers, business folks. So yeah, I think it's very much open to anyone who is a professional in their own space to come and learn those skills. Now, there will be always a little backlash from the legal community. It's not quite, I would say, obvious, but there'll be always a bit of, that it's a bit of that kind of, I would say, not an opposition, but to say that how can you be a mediator without understanding the law? But there is a space for an expert in any place. So it depends on what kind of a mediation style you are, of course, acquiring. As a facilitative mediator, my role is to help you talk. My role is to help you design the process. My role is to help you prepare for the session and coach you on how you're going to speak and how you're going to frame your sentences, how you're going to figure out what your interests are, how you're going to express your interests, how you're going to brainstorm your solutions. I don't need to know construction law for that. But there might be a time during the mediation where there might be a point of law or fact that might come into the play where parties need clarity on that before they start brainstorming solutions. And that's when you can both parties mutually invite a construction law expert or someone from the engineering field to come in and provide that expert advice so that they can move on from that niggling bit and start finding a solution. So there is room for an expert advisor to come on board. Or right in the start, you say, instead of having someone come in as an expert advisor, let's find a trained engineer already to be our mediator. But that engineer has to be trained to be a mediator, because remember, it's also those person skills, the process skills, and the subject matter, which are both important. So if you feel like you need to have a subject matter expert to handle a construction dispute or an environment dispute, great. You should choose that kind of a person as your mediator, but make sure that person is trained. Right? Just a subject matter is not going to help you, because if it could have helped you, then you would not have come to mediation. You would have just gone to that person and said, hey, help us sort this dispute out. We are, really going down the drain with the stuff. So the important thing is that subject matter expert has to be trained in the process to, as I said, to rephrase, to summarize, to ask proper questions, to calm people down, to anchor emotions. And if that person is also a subject matter expert, is nothing like it. But not like I'm not a construction lawyer, and I don't have expertise in construction law. But if you can hire me as a mediator, and I can help you design the process, I can reach you to that point where you all are really talking to each other, because you as disputants know exactly what's going on, right? Problem is that you all have not been able to talk to each other and figure it out. That's where I come in. Okay, I'm not a counselor, I'm not a communication coach, I'm a mediator, and we have little elements of everything. And that's what we bring to the table to help you continue talking, to help you continue negotiating. Right. So, and if there is a point, say 3 hours, 5 hours down into the mediation, there is a point of fact or a point of law that needs an expert to come in, that expert is brought in at that point of time. We sort out a little niggle, that expert goes back, we continue with the process. So there is room for the expert.
Thanks, Jonathan, for your response. I'm very happy to know that anyone can become a mediator, but the training is important. And what would be the nuances of that training is still to be debated.
Yeah, I mean, there are a lot of training organizations in the country, and we are not going to take this opportunity to call out any names, but I think
yes. So
what I would suggest,
wanted to say is that your point is well taken, that a training is needed to become a mediator, and therefore, what kind of training would it be able to deliver justice? Wherein I think, like the tribunals do, they have one person mandatorily from law, so that, as you have already said in your argument, that the mediation agreement must be watertight. Who will ensure the watertightness of that? So anyone can become mediator, but the training and the watertightness of that agreement is important. Those are my remarks. That's all.
Absolutely.
Thank you,
I
Jonathan.
completely agree with you. I completely agree with you.
Thank you, Rahul, for the
I want to kind of just highlight very quickly in just few seconds, Kritika, that there is the role of the lawyer as well in the mediation. So if you're in a construction dispute, environment dispute, insolvency dispute, banking dispute, you might have the major parties in the room, but the lawyers are also sitting there. So that's why in the start I said all important stakeholders are at the table, because they help you make a watertight agreement, as Mr. Srivastava has said. So they will help you make sure that whatever you have agreed to is not going to cause further conflict after this. You've come to sort it out, so you don't want to cause further conflict. So yeah, as a space.
Thank you, Rahul, for the question, and thank you, Jonathan, for that explanation. While we're running out of time, we have one question that we would request you to answer. This is Navneet sir's question that he has put in the chat box. While we've covered almost every other question. Can you also answer, Nishant and Jonathan, how can parties figure which is the best route of resolution for them? Is it arbitration, or is it mediation, or is it conciliation? How does one choose from these options, or can they even choose more options than one?
Okay, so thank you for that question, Kritika. Pertinent question, but I think the first route that they will have to take in terms of what mechanism they should pick up for resolution of a dispute, they will have to go to their contract. Because all contracts have a dispute clause, right? I think that is where you'll have to start from. Because as parties, when you entered into that contract, you agreed that, okay, we will first go in for mediation or litigation, negotiation, whatever. There are so many, clauses that we see today that if there is any dispute that arises out of this agreement, the parties are first going to amicably resolve it through communication amongst themselves. If they're not able to resolve it, the parties would, look at hiring a neutral third party or a mediator. And if the mediation fails, then, the party will submit the matter to court, or the party will submit the matter to arbitration. So you have to look into what your contract says, right? If there is no contract, then ideally, you would want to try to resolve the dispute amongst yourself. So either through negotiation or with the help of a neutral party that's a mediator. So that, the conflict does not escalate too high on the ladder of conflict, so to say. So yes, if there is a contract, you have to, go through, what you've written. That will be the first recourse that you take. And if there's nothing written, then of course you do have all the three options open. And I always say that, okay, first start by communicating directly. You will have the adjudicatory mechanisms like arbitration, like litigation. They are always, available to be explored. But first, start. If communication is possible, start with mediation, negotiation, or conciliation. That would be.
Can I just add to that, Nishant, very
Yeah.
quickly? I think I think part of the question was, can you have a process within a process? Yes. So ideally, what we want and what we try and preach to everyone is, as Nishant said, try it out as your first dispute, as your first process, even before the dispute escalates, even before you decide to hire a lawyer or get out and take this to court, try it out first. But if it's already in court, under Section 89, you can ask the court to refer that to mediation. Sometimes judges do that themselves. If it's already in arbitration, lawyers can come together at the stage of appointing an arbitrator under Section 11 of the Arbitration and Conciliation Act. And at that point of time, instead of appointing an arbitrator, you can try mediation for a couple of sessions, for a couple of hours. So you can pause a formal process of litigation and arbitration and try mediation for some time. So that process is already, that provision is already there in the different legislations, both in the CPC and the Arbitration and Conciliation Act. But I agree with Nishant on that point. I think it's important to ask yourselves, what do you want? In a mediation, if in a mediation setting, my final point on this, in a mediation setting, if Nishant and me are in a dispute and we want Navneet to only listen to us, help us talk, reframe situations, help us not to go up against each other and say stupid things to each other, to help us design the process, brainstorm, and Navneet's good at all this stuff, then Navneet's our mediator, then we want a mediator and we want a mediation. But if I don't want to break my head about brainstorming and finding my own solution to the problem, and it's too much of a hassle, and I don't have time to get into emotions, and I don't like getting into emotion stuff. But I know Kritika can actually sort things out, and she's good at the subject. And she can probably give us a solution, and then Nishant and me can decide whether we like it or don't. So we appoint Kritika as a conciliator. She's not a mediator, she's a conciliator. She might give us a suggestion, but I can say, no, I don't like it. Okay. And then we'll probably go to court. Or we want someone like Mrinali, who is the arbitrator, who listens to both of us and says, according to what your contract was and what I've understood and the evidence in front of me, this is what I decide. I award I give the award basically says that Jonathan is not liable for the damages, and that's the end of it. So I need to know what I want and accordingly decide which process I want to take. So that's important at the end of the day.
Thank you so much for this interesting conversation. My takeaways are 3 C's: communication, clarity, and choice from this whole discussion.
Do we have any other questions? Good evening, ma'am.
Good evening. Hello, everyone.
Good evening.
And I would like to congratulate both the speakers who have made a great effort and have really simplified the understanding of mediation, which is a need of the day. Even while sitting in the court and while practicing, I know that how important mediation is to resolve the issues, not only to lessen the burden of the court, but to give the relief to the people in actual sense. Because I have seen many of the times it happens that whatever order we get, sometimes it does not really do justice. Though it is followed, but mediation is the best way. And I think Mrinalini knows it, that in my court, whenever the matter used to come, I used to always see how it can be mediated. Every case has a possibility of mediation. So if we look at it from that point of view, it'll be great.